So I mean, we can help you with any marketing endeavors that you need. We have, like I said, lots of great tools to help you expand your business. We have an amazing farming tool that's really great if you're looking to get out mailers to certain neighborhoods or looking to contact them via phone and email. This system will help pull up that information for you and then also apply like filters if you're looking for people that own a VA home, for instance, or foreclosure. They just had a death on the property. This system will pick up all of that. So if you'd like to visit with me over that and help you kind of lead generate for this year, if you are kind of drying up and you want to really infiltrate a certain area, get with me because I'm happy to help you with that. Gloria's here today. She's one of our amazing escrow officers, and she's located at our I-10 Dominion office. I know some of you have had phone there already, so thank you. But if you haven't, you should definitely send your next contact to Gloria. Even if you're representing the buyer, how good are you at negotiating, right? How good you are. But we are so thrilled to be here. Happy early Valentine's Day. Laura's gonna be talking about real life situations that she's had, so this is gonna be super interesting. She's got over 20 years of title experience, so she's seen a lot. And I can't wait to hear all your stories. I'm excited.
Well, good afternoon, everyone. So my name is Gloria Campos, and I'm with Over Public Title. I've been in the business for 25 years. And I started off 25 years ago as a cleaning lady. And Spanish-speaking customers walked in, they needed a translator, and I went and translated my closing. And then fast forward 25 years later, I'm the vice president of Over Public Title. So anyway, so we're gonna go over some situations that I see not on a daily, but within my 25 years. So situations that have caused the agents either their license, a lawsuit, a trick complaint. And we're just gonna touch on those here just so that you can see how a little check mark, not checking the box, can lead to somebody losing their earnest money or even a complaint. So we're gonna start with page 1, and that's the parties. Let's start with number 1, the parties to the contract. And this is open discussion, so we could you could ask questions as we go along. So number 1, the parties of the contract, or if you are representing a seller and the seller, let's say is the kid or an heir of someone that, the property belongs to mom and dad, you got to make sure that you write on there the estate of the deceased party. It's not just the person that you're dealing with, which is the one heir. It's the estate of that you must put on there because that already notifies that there's a deceased party. And then after, whenever we figure out who the heirs are, it's really important for you to get all the heirs to sign your contracts and sign your exclusive rights to sell and all that, because in reality, you only got one of the sellers to agree when you can have up to, however, I've had up to 12 heirs signed. So you got to be careful with that. For buyers, if you deal with investors and or wholesalers, whoever, you've got to make sure the correct language is on buyer if you plan to assign the contract to another party. So, for example, if you're getting a really good deal on a property, you just want to secure the property. So you can put buyer's name, Lisbeth Ramirez, but if you don't put the and / or assigned language after that, your contract is not assignable. You got to make it assignable by adding that language to your contract. If the and or assigned is not following your name of your investor, then you as the buyer are the ones that are in contract with that seller. So if you don't intend to be the end buyer, and then the seller gets another offer, you don't have the cash to pay it, the seller has the right to terminate the contract because they were in under contract with you, with no condition of you to assign the contract to anybody else. So remember that and or assigns if your intent is to have an end buyer. Okay? All right, for legal description, we go off of lot and block. Okay, so we ensure the legal description, everything for us is the legal description. We really don't care about the property address because the city could change that whenever they want. I'm gonna give you a scenario I had with a legal description. Okay, a few years back, I closed a transaction of 15-acre tract in Natalia, Texas. Okay, it included a nice home on 15 acres. A client from California came in to Texas, bought that ranch, stayed here for a few years. Then he decided Texas is not for him, and he needs to go back to Cali. Okay, he asked the same realtor that helped purchase the home if he can now list it. Okay. And he says, I only want to list the property on 5 acres and I want to retain 10 acres because just in case I ever want to come back, if I decide to build and whatever the situation might be, I want to be able to have 10 acres to do something later. Well, perfect. That was the agreement. 5 acres, the house on 5 acres, he retains the rest. The agent that was representing him, instead of putting all the new information on MLS, apparently there's a way to copy a prior MLS. He copied and pasted, I guess, the information into a new listing. Okay, created the new listing for the sales price that was only supposed to be like 5 acres, right? Put it on MLS. We got a contract on it. I got the contract. The buyer got financing through USAA, and we closed. We funded. We went on our merry way. Everyone's happy. So we got until a few months later, the seller calls me from California and says, Miss Campos, I just want to know how long will it take for my 10 acres to show up under my name? And then I was like, I'm in panic mode, right? Like, oh my God, did we do something wrong? Like, did we convey the wrong property? So then I start digging through my file and whatnot, and I looked at a contract and it said 15 acres. So the survey we had was 15 acres. Everything that we had was 15 acres. So then I called him back and I'm like, sir, I'm so sorry. Like, you sold 15 acres. You sold the whole thing. He said, what are you talking about? No, I didn't. I sold 5 acres. I was supposed to retain a 10 acre and blah, blah, blah. I'm like, that's not what happened. I went back, we pulled MLS listing. MLS listing showed the 15 acres. The contract that we received, he says, I said, sir, you signed the contract that says 15 acres. He said, I didn't sign nothing. They sent me something on email and I just had to click. It was a DocuSign. So he never read the contract because everything he did was to DocuSign. Long story short, he sold the 15 acres for the sales price of the 5 acres. He sues Oregon Public Title. He sues the buyer, the buyer's agent, the listing agent, the broker. He sues everyone. Okay? The buyer's agent, us, everyone basically we're out. You know what I mean? Like, once we provided our file, like, this is what was presented to us. This is what we closed. What the agreement was between the listing agent and the seller, we have no idea. But we closed what was presented to us. The buyer got the lien against the entire 15 acres. So it's not like, okay, well, we could cut a piece back to you like it's The one that ended up taking the fault for everything was the listing agent. The listing agent no longer has a license. He lost his real estate license over this transaction. Okay. And they had to, I know that E&O insurance stepped in and paid, I believe, what was the cost or the value of the 10 acres that was conveyed, because apparently there was documentation of the only the 10 acres or the 10 acres that was supposed to be retained. Okay. So don't copy and paste. Okay.
So, wouldn't the county need to replat that before he can bring it back?
Yes, so we should have, what should have happened was we should have sent a surveyor out there. If it could have been done prior to, or even with while you're in contract, we could have sent a surveyor and had the surveyor cut out, our 5 acres, the property with 5 acres, and that's going to be our legal description. The surveyor would have made us an exhibit A with all the new meets and bounds, and we would have closed using that legal description, and the seller would have kept the other 10 acres. But we weren't told. But to be honest, the buyer and the buyer's agent were not aware that only 5 acres were. They got a steal. So that's why they're like, they got under contract real quick, like 5 acres, they got 10 free acres, So anyway, no copy and pasting. Next one, sales price. All right, I have another scenario with sales price. Cash is cash and financing is financing, right? Financing means you're getting a loan. Someone is letting you borrow the money. You don't have the cash in your pocket. You're in the bank. That's what financing means. So when you're using a hard money loan, what is that?
No.
They always put cash.
It's a financing, right? Yeah. Mostly every contract that we get says cash. When there's a third party, but it's not a cash deal. Hard money lending is not a cash deal. That is financing. Okay, here's another scenario. I get a cash deal, $600,000 transaction, $6,000 earnest money from the buyer, and contract gets executed and receipted as a cash $600,000 offer, right? The listing agent takes this offer, even though it's the lowest offer. They take it because it's cash. Mm-hmm. And they don't want to deal with the lenders, with financing, with the freight. They don't want to wait. So this one was a quick 7-day, 10-day turnaround time. Let's go. The listing agent took it. So it's time now. Closing date has come, and I'm ready. Seller's ready. I send a HUD to the buyer's agent. All right, my seller's already scheduled a sign such and such time. What time does your buyer want to close? The buyer's agent says, oh, my buyer's still having to turn some things in, some documents in the lender. I'm like, the lender? And I'm like, this is a cash transaction. Oh, no, I mean, it is cash, but it's hard money. Well, then it's not cash. There's a seller financing. It's contingent to financing. So seller gets livid, right? Because they took the lowest offer. They just made them waste their time. Now we're on a contract. Okay? And guess what the seller says?
Gonna sue them because it's not happening.
I want the earnest money. Contract is canceled, and I want the earnest money because they didn't come home. It was a cash deal. The buyer's agent is freaking out. Like, no, we're gonna close in 3 days. We're gonna close in 3 days. Maybe they close in 3 days, but at this point, it was a principle. The listing agent was upset. The seller was upset. And it was either you forfeit your earnest money or you're getting a trick complaint. Regardless, the buyer's agent ended up getting a trip complaint from their client because they cost their client $6,000. So the buyer did lose the earnest money of $6,000. It did go to the seller, and the buyer fired the agent and filed a threat complaint, and I don't know what happened next. I don't know if the buyer's agent ended up paying the $6,000. I'm not sure. Probably maybe took them to small claims court or whatever. But that's what happens when you gotta make sure your financing is correct. If it's cash, it's cash. You gotta make sure that there's money that you could provide, that it's cash, okay? Right, number 4, leases. With this new contract, everyone is aware that you are supposed to provide any leases that are currently on the property. If you're representing a seller, that they have a tenant in the property, that lease must be presented to the buyer. And the buyer has the right to terminate that contract if they see anything that they don't like on that lease. Okay, next one. Paragraph 5, earnest money and option period. All right, here's a good one. So, years ago, title companies were prohibited from touching option money. Do y'all remember back in the day? We couldn't even, I mean, we wouldn't receive for it. We would take it. We would put it in a FedEx.
You don't want to touch it.
Oh, yeah. Like, FedEx, and there you go. You know, here's a tracking number, but we couldn't touch the earnest money. I mean, it was a big no for title companies. Well, that changed with this new contract, right? And now we can receive for the earnest money and the option. Now it's even one check, where before it had to be 2 different checks, one for the seller, one for the title company. Now it's just one wire or one check payable to the title company, and now we receive for it. All right. So another scenario, I received a contract Monday morning. I received the contract at around midnight. And I saw it Monday morning when I came into the office. And I get the contract, we start processing it and everything. My order entry comes to me and says, "Do you think that this is wrong? They have the earnest money as 100 and the option money as 1,600. Could that be a mistake?" And I said, absolutely. It was just they just put it in the wrong line, right? It's 1,600 earnest money. I'm sorry, it was $2,600 earnest money and $100 option. I said, let me call the buyer's agent. In this case, it was the buyer's agent who had referred the contract to me. She did good negotiating. And so I call her. She's my client. I'm like, hey, girl, I just see that this is transposed. You have them in the wrong lines. And she says, "Oh my God, amiga, I'm so sorry. Like, it was midnight and I just wanted to get my offer in, and I was so tired, and I was just wishing to get my offer in, and I just didn't see that mistake." And I'm like, "Oh, that's okay." She's like, I'm sure, I'm calling the listing agent. I'm sure that he'll fix it for us and whatnot, and I'll send you an amendment." Perfect. She'll fix it. I want to say maybe 30 minutes later, I get a call from the listing agent, right? Now, as listing agents, how many times do you tell your seller to go pick up the option money? Never. Right? Never. Well, guess what happened with this one? Oh, the seller called, the listing agent calls and says, "My seller is on her way." Oh, first wanted to know, did the buyer drop off the funds? Yes, they actually dropped them off this morning. Perfect. My seller's on his way to pick up the option. And then we're like, oh no. Like, so then I call the buyer's agent. The seller's on her way to come pick up the option. And then she's like, what? So the listing agent's like, too bad. Too bad. You secured your client $100 earnest money, $1,600 belongs to my seller. That's what you wrote. That's what's on the contract. That's what the seller agreed. Both parties agreed to that. Is it true? Yes. It's true. It is true. So we had to cut a check, $2,600 option to the seller right then and there, and give it to him. The buyer's agent is devastated. The buyer's agent's like, just don't let my buyer know, please. And regardless, I will pay it. If the deal, worst case scenario, the deal falls through during inspections, and we're done. Buyer just lost $26. And then she's like, I'm just gonna pray that the inspection goes well, and if it doesn't, I already talked to my husband, and we're prepared to pay the buyer the $26. And I said, okay, sounds good. Luckily, in this case, it made it all the way to closing. The buyer did get credit back, but got a credit of earnest money of $100 and got their option money credited $2,600 as an option money credit. But at least it went through. So what would have happened if it didn't go through? You just cost your buyer $2,600, right? Okay. Now, still on this topic of termination, the option period. So there's on the amendment, you have the option to extend your option period, right? Another situation, this one is $1,500 earnest money. And the property they go to the inspection, they have a 7-day option period, paid $70. And the inspector says, the foundation kind of feels, funny, but I recommend you bring a structural engineer to come and do the inspection because I'm just not sure. So they hire a structural engineer to come out to the property. They provide an amendment to extend the option an additional 5 days for exchange of $1. They put $1 on that amendment, which I see all the time. Why? I have no idea why agents put $1 on extension of.
I think actually the impression they have to put something.
Maybe, but my amendment said $1 for 5 additional days. Okay, so they go and get the inspector out there, the structural engineer, and then on the last day, sure enough, it's the foundation problems. So they sign the release of earnest money. We're still under the option termination. We want the earnest money back, $1,500 back to the buyer. Here's your $70 to the seller. We're done. The seller comes back and says, no, $1,500 belongs to me. And everyone's like, what? Why?
$1.
They never got their dollar. The agreement was in exchange for $1, you get 5 additional days. The buyer's agent never got the dollar from the client or from his own pocket. And then went and took the $1. There was really no exchange. They should have put 0 for 0 money. Yes, we get 5 more days. But since he put a ticker on there, he didn't turn in the $1 that cost his buyer $1,500. So the money stayed in dispute. They were going back and forth, but the seller has an attorney friend. And then letters start going out, attorney letters, right? After the attorneys get involved, the buyer walks and the buyer agrees to give them the $1,500. However, the buyer's agent pays the buyers back the $1,500. The buyer's agent loses this client that he already has approved. Only Lord knows how many properties he showed to them already, and gets a check complaint. Everything over $1. Yep. So watch out with those. If you get anything out of this, remember, don't copy and paste on the option. Don't put them in.
It's a question.
Yes.
You said about 0, but I always thought it had to be a value for those days.
I mean, if there's I don't know why there would have to be a value. Like if it's 0, if they're giving 5 free days, I don't know. But if you have to have a value and you have to put that, maybe we gotta ask Moody that if it's why there has to be. If there has to be $1 or $5 or something, you gotta make sure you give it to them.
I've had that before. I've had
penny.
Oh, yeah.
Well, you gotta make sure you receive that penny.
I did.
Yep, because
Maybe there is. Well, I don't know. I'm not aware of that. I'm not either. Right. This is $0.
Yep,
I'm pretty sure I've seen $0.
I see
Yeah.
zero all the time.
Yeah.
I work with investors, and some investors, they already know what they're getting into, so they don't need an option period.
No.
They're just moving forward. So we put 0.
Yeah.
There's no necessity for, earnest, yes, but option, no.
The extension of the
It's from the amendment.
Yeah.
To extend the option.
Right.
It does say for X amount of dollars,
Yes.
they're extending the option for X amount of days.
But I think it's just a blank warrant.
It is a blank negotiation, correct?
And so if you leave it at 0, and it's
Zero.
accept, then it's 0.
I mean, I would put a big fat zero.
Yeah.
Zero. Like they don't.
And then when you send the dollar in, don't send it cash because we can't accept cash.
Exactly. So for $1, you're winning a cashier's check?
Yes.
Money order.
Well, it's funny you mentioned that because that happened to me on this very last transaction I had. We had to extend it for that what happened. But the buyer's agent said, well, just put $1, just don't worry about it. And luckily the contract went through because I don't even have to.
Oh,
I'm like, well, don't I need to meet you? I need to give you the money or
Maybe that's the
Already.
assumption that the dollar situation is the
Yeah.
same, maybe.
Well, it came like, you lose your money.
you know,
You can earnest money over that.
So you don't have to go forward. Funds can be
We have those.
sent.
Yeah. Well, we have like the app where you just take a picture of the check if you, yeah.
All right, title policy and survey, that's a negotiable item. Okay, so if you guys either want to split costs, it doesn't have to be one or the other, the buyer or the seller. If you're trying to convince if you're representing a buyer, you want to close the door with public title, you could say, well, we'll pay. All okay. And you could check both boxes up in half and they net it for. Okay, all right, what else? Let's see, survey. Next one, survey's a good one. This is, ooh,
I bet you have a lot of students.
I have a lot. A lot of stories. Right. On survey, even my most seasoned agents get this one wrong. The survey. All right. If you're representing the seller, okay, if you have the listing, whenever you go to your listing appointment or whatever, ask them if they have a survey. That will answer, this will help you already with this paragraph. If your client says, I don't have a survey, all right, well then don't contract with paragraph 1 checked because that one says you do have a survey. All right. So now only option 2 or 3 are your only options, right? Or you put on your agent remarks on MLS, no survey. So the client knows that you've disclosed it. Or if you can ask your client for it, upload it in MLS and additional docs with your T47. Now they don't even have to be notarized. Before they would have to be notarized. T47s don't have to be notarized anymore. Maybe you can get a copy of that, upload it to your additional docs. You've already complied with this section. Now, the first section says, or number 1 says, after X amount of days after the effective date, the seller shall furnish to buyer and the title company the seller's existing survey and a T47 affidavit. And, okay, buyer shall obtain a new survey at seller's expense no later than 3 days prior to closing if seller fails to furnish within the time prescribed the existing survey and the affidavit. So what does this mean? Oh, and then you continue on the paragraph and says, buyer shall obtain a new survey at seller or buyer's expense. Okay, that's what confuses everyone. Because everyone thinks, or the listing agents sometimes think, that because they check mark at buyer's expense, their client is free. And then now the survey is at the buyer's expense because it's check marked there. That's not what it says. That's not what it says. The contract says that within X amount of days, let's say 14 days, the seller has to provide the existing survey and the T47 within the first 15 days of the effective date of the contract. If they don't provide it, a new one is automatically at the seller expense 3 days prior to closing. If the seller didn't provide the survey and the T47. So if they provide the survey alone, but they didn't get the T47, will that still work? No. No. It says both. Both. Has it happened before? Absolutely. We had a client, a seller, selling a brand new home, military customers that bought a brand new, I'm not the builder, but they have only owned the home 2 years. And so they have their survey. It looked amazing. It was a beautiful survey. And but contract said 14 days, and they found their paperwork because they were moving, and they had everything in boxes, and they had to go through all their paperwork to find the documents of the closing documents. They finally found them 15 days later. So they were 1 day past, right? Regardless, I get it. I get the T47. I get the survey. We approve it. It's amazing. No problem. My assistant sends it to the buyer's agent. Here's the existing survey and the T47. Or Republic Title approves it. We can use it. We send it to the lender. The lender's, it's beautiful. We can use it. The buyer's agent says, I don't care what y'all approve. I don't care if you could use it. They just cost, they have to buy my buyer and use it. And then we're like, why? Like, this is a perfectly good one. Like, so stupid. But it's, I don't know if it's
Ego.
ego. They just
More evil than evil.
maybe. I agree. But we did make it all the way to closing, and the seller ended up having to pay an additional $500 for a brand new survey. And guess who ended up taking or giving a $500 credit? So listing agent gave a $500 credit, 450 the exact amount of survey, to pay for the.
But I mean, it is what it says, so it just makes you pay attention to all the dates, because, I mean, yeah, it seems like a rude thing, right? Oh, okay, but it is the
But
contract,
yeah,
that's his license too, that he's
Correct.
protecting, so.
The contract does say you have X amount. Now, it says that buyer shall obtain a new survey at buyer or seller's expense if we don't approve it. So it says if the title company or the buyer's lender does not accept the existing survey, then the buyer shall obtain a new survey, and if that buyer box is check marked, now it's a buyer expense. How would this work? For example, when I purchased my home, I didn't have a pool. It was, I have a survey without a pool, right? So now, fast forward 2 years, I now have an underground pool. I don't have a survey with the underground pool, right? Because I still live there. So I'm going to go pay for a new survey right now. So if I'm selling my home and I sign the T47 and say I added an underground pool, and I provide that to my listing agent, my existing survey, and my T47 where I disclose the change, I still did what I was supposed to do. Now, is the title company and the lender going to accept my survey? Absolutely not, because now I have an underground pool change, right? I changed the survey. I changed the pretty. So since my buyer lender or the title company is not accepting the new survey, that's on my point. And I provided my existing survey and my T47. If your lender and your title company needs a new survey, now it's at the buyer's expense. See the difference?
Wow, check.
If that
And how many times have you had to have this conversation, right?
with the most experienced brokers. We miss it. So just pay attention to the survey. So if you're representing, again, the sellers, if you get your offers, look at the survey. If you know that there's not an existing survey, kick it. take back the offer. Like, hey, or whenever you counter, you change it to a buyer's expense and have them initial, but just to protect your seller. Okay? HOA, that's a whole another addendum, and we'll touch HOAs at the end if we have time.
Oh, come on.
All right, let's go on to the next page, property condition. What are those called? The seller disclosure. Seller disclosure. How many of y'all have your seller fill those out before you even go live?
Oh, yeah.
Yeah.
Okay, well,
They always ask me.
not everybody does. Not everyone does.
We work for Rudy.
We are PRG. So the ones that are not PRG, they you know a lot to not get their sellers to sign the seller's disclosure and even upload it. That has to come later, right? A lot of times, that's why everyone always picks 3 days. But a lot of the the days that I see on the contract, like within X amount of days, 3 days, usually what's on there. After the effective date, seller shall provide and deliver the notice. If buyer does not receive the notice, buyer may terminate this contract at any time. There's a loophole right there for the buyer at any time. That means they can make it all the way to receiving closing instructions, and at the end, if the buyer doesn't like their payment or interest rate, you can provide the seller's disclosure within 3 days. So guess what? I'm out. It could happen. Like it does happen.
Even though you did provide it, but it was within 3 days, but they can say nothing about it till.
Absolutely. Absolutely. These are loopholes on the contract.
Get yourself proof of delivery.
Mhm.
Acknowledgements.
So that's why seller's disclosure, you get those filled out at the time of your listing. Leave it there before you upload your go live. Upload that document in additional docs and make sure you have it there. So and then look at it and make sure that it says that the buyer has received the notice. Because a lot of times, I've spoken to a lot of these agents like, girl, I'm only making sure that what the offer is, what this and what commit, and they look at all the little details.
I think one of the things is when you send it, when they sign it, it's on them.
Yep.
And if you send it within those 2 days, then I would say to be your covered. Because they were sent, whether they received it or not, or signed for it is another question.
Well, the date better match the
Yeah.
3 days.
That's
all that matters.
Exactly.
And what I do is we just tell them, as soon as you fill out the seller's disclosure notice and get it back to me, I can get it on MLS.
Yeah.
Good. And it just puts a little pressure. Well, if you go down there, you have to turn this in. That's when you need it. And then I put it in the additional box.
Good. Yeah. So that's another loophole. That's other places where I've seen a buyer get earnest money back almost all the way to the end of the transaction, where the seller has already lost 45 days, 60 days, but there's always going to be a loophole and someone's going to find it. So that one's one. I guess what I'm trying to make y'all understand are just try to cover up, make sure those loopholes are not there.
Yeah.
Cover your base.
So instead of 3 days, would you recommend?
The 3 days is okay.
Yeah.
If you're sure that you already
Yeah.
Okay, next page. Here's a good one. Buyer accepts the property as is your first option, or buyer accepts the property as is, provided the seller at seller's expense complete the following specific repairs. Okay. This is different than this is how normally it goes, right? So you're under contract, then you got 17 days for an option to get your inspector out there. You get your inspection report, and then now here comes an amendment with repairs.
Yeah.
Okay, repairs that. Now at that point, I've sold many properties and I've gotten reports, okay, there's 20 repairs. As a seller, I get to pick. Well, out of all these 20 repairs, I'll do 15, but these 5 are dumb. I'm not gonna do it. We have the option, pick and choose what repairs we do and we don't do. Unless they're minor repairs, but we don't know that yet, right? Okay. This paragraph number 2, which a lot of people don't see and don't pay attention to, these are non-negotiable repairs because buyer and seller already have them in writing and agree to them. Okay, these are not like the amendment that comes in that are negotiable. This is not. Now, so what happened? So listing agent gets a contract and doesn't notice that the buyer's agent puts on there that the buyer wants to move. Because when they went to go see the property, the roof looked, it needed a lot of, it looked in stress and it needed repair, right? So the buyer's agent automatically put that on there, seller to replace room prior to closing. Buyer, the listing agent never paid attention to the my God. They love the offer. They accepted the offer. No seller constituents, no nothing. They took it. They accepted the. So now we're like at closing, and we're like, okay, well, when is the roof repairs completed? When can we close and whatnot? And the listing agent and sellers are like, what are you talking about? There's no roof repair. And then I'm like, well, contract. So then I go to the buyer's agent. I'm like, okay, so maybe there's no roof repair. Like, no. They're supposed to provide a new roof and we need the invoice. So how much does a roof cost? A lot. A lot. Well, in this situation, they were under contract. It was an agreed repair on the contract that the listing agent missed. The listing agent forfeited commission that covered, and the seller had to pay the other half actually. And the buyer got a new. So
It does
Okay,
plug right in, doesn't it?
have you had with these things that I'm sharing with you, do y'all ever even think about it? Like,
I put fence posts, like there's things that are visible that I have put on there.
like a fence post right
Fence,
here?
yeah, because it's visible. You know what I
Yes.
mean? I'm not gonna, I haven't jumped on the roof, so I can't
Yes.
tell you the roof.
So
But I put things like the roof or
roof
the
repair.
missing doors. I'll put
Yes.
missing doors on the closets.
Yes.
Like I'll use that.
Or-
More visible.
So seeing every must be cleaned by a professional clean or carpets
Seeing
or carpets to be replaced throughout the home, like things like that. But a new home, they pay for it. All right, let's move on. Residential service contracts, the home warranties. Back a long time ago, we used to order the home warranties for y'all. Unfortunately, we don't anymore. And I'm gonna tell you why. So we used to just pick whatever home warranty. They come and bring us flyers to our office. And depending which if there's $500, $600, $700, whatever they could get the most coverage, we just pick the flyer and we used to order the home warranties, right? Until we got sued and we ended up having to pay for an AC. Why? Because the contract called for $500 and we ordered and we picked, I think it was American Home Show. We picked the $500 plan and we ordered it and we placed it, right? We thought we were doing a good thing. So the AC goes out, the buyers call and say, do I have a home warranty? The contract says, yes, you do. Here's your policy number. Call them, blah, blah, blah. Well, it turns out that whatever broke is not covered by the policy. They needed additional coverage to cover whatever. And we just picked the basic plan, right? So then we get emails, and or the emails are going to our corporate offices, like saying, why did we pick the home warranty for them? And why didn't they get the option to select their own home warranty and even pick additional services or additional covered items? They didn't get the opportunity to do that. We just chose for them and we ordered it. So is it true? No.
Well, yeah.
It's true. So just pay for the AC. For Republic Day. No, we paid for the AC, and since then we learned our lesson and we never ordered a home warranty again in our life. That works. But do you order the home warranties for your clients, or do you tell your clients which ones? Like, here's the pamphlet. Like, do you steer them to a certain home warranty? Because remember, we have relationships with people. With this person is like, oh, and from this home warranty or this person, we try to beat them, right? And then this is what's happening because we were steering them to use a certain provider, and it is we give them several options and then they choose. Good. That's what you're supposed to do. You're supposed to give them three different options and let them respond. If you're gonna place the order, that is fine. Place the order, but have it in writing from them in an email or a text somewhere where there's evidence that they told you which one, which plan, and which company to go with.
I'd use DocuSign and whatever plan they choose.
Yeah.
Get the pamphlet and type in there something that you chose this thing. Please initial here, sign here, and it's documented.
Good. So even the home warranty has cost like that could get you in trouble.
An AC unit.
AC unit. Yep. All right. Next one, let's go to number 11, special provisions. When special provisions, we used to tell everyone, just tell us what you want us to know. Like, for example, if the buyer, there's a lot of cases where you're negotiating contracts, you're getting an amazing deal, and the buyer is going to pick up all the closing costs, right? So I would tell the clients, just put it on there. Buyer to pay all closing costs, including sellers. Like, that means buyers picking up everything because they got an amazing deal. But now I've been told that brokers are telling you not to put anything on there, and that's okay. You listen to your broker, don't listen to me. So I don't know why. I just don't know
It's like
why.
practicing.
Yeah, maybe.
So
Okay,
that's the biggest thing.
that's fine. Listen to that. All right, next one. This one is whoa. Okay. This one cost a listing agent of mine, a really good friend too, and she was arguing with me, and I was like, you just but she just and very seasoned agent. Okay, she thought that the commission goes there, and it's on paragraph 12, and if it's there, it's automatically a buyer expense. Well, remember now with the no commission disclosure on MLS, now you what do y'all do now? Paul, is there any commission? Blah, blah. Okay. So if you put the commission on paragraph 12, this is an agreement between buyer and seller. Okay. So this says that the following expenses must be paid at or prior to closing. Then it says seller. Highlight that piece because everyone misses that. Seller shall pay the following expenses as seller expenses. Right? Y'all see that? And then part of that is, look at B, the following amount to be applied to the brokerage fees that buyer has agreed to pay, which is X amount of the sales price and an amount not to exceed whatever the amount towards buyer's closing costs. So this is where you ask for your commission and the closing costs paid for the buyer. Okay. So when there's some listing agents that sometimes are only going to offer 2%, 2.5%, a lesser amount than 3%, right? But then they don't notice that the buyer's agent puts in the difference in paragraph. And then they think that no, that's the buyer's covering that. Like the buyer's paying for that additional 1%. So this recently happened. So we had a contract where this paragraph on B, it said 1%. Okay. And then on page 10, is it page 10 where the commissions are? Yes. On here, it said 2%. right? Okay, so 2% is broker to broker, right? 1% is seller to buyer.
Exactly. So that's how you compensate the 3%.
Yes, ma'am, that's what this buyer's agent did. He got his 3%. He, like, the listing agent thought he was only, my seller's only gonna pay 2%. No, your seller's paying 3, because the seller agreed to pay 2% to the broker, your broker fees, and then an additional 1% that he agreed to cover to the buyer for buyer's expenses. Is that making sense, or do I repeat?
But
Being-
in your
being-
should not be paid out, right? Whatever you put on page 10, because that's just for informational purposes.
That's the agreement. There is a broker to broker compensation agreement,
Right.
and if that says 2%, then that needs to be paid. So if there's, in addition to the broker to broker, you accept a contract that says 3% here, you just cost your
Where's here?
seller
Where's here?
Right.
here. 12,
No,
page 6,
6, okay.
paragraph 12.
Yeah,
This section right here.
Right.
If your buyer, if a buyer's agent puts 3% here and also has a broker to broker compensation agreement and put it in both places, that buyer's agent just got 6% commission.
Well,
That means you're not getting paid as a.
That's exactly what happened to this agent.
that means what?
The listing agent, you're giving away your commission. So
The listing agent and
in the I have already had multiple situations with agents and fighting and it gets
So
ugly.
what's the solution?
You do one or the other.
One or the other? One or the other?
So like if you're gonna, or you go at listing agents, pay attention to
Right.
what they put on there. So if they already asked a commission on paragraph 12, you don't sign the broker to broker.
Yeah.
They already asked for it on
Okay.
paragraph 12.
Okay.
You see, or if they sent you an offer with a broker to broker compensation 3%, then you don't accept an offer with 3% on here.
Okay.
On paragraph 12.
EXP, their agents do not use the broker to broker. The EXP agents will put it on section 12, section B,
So
because the broker doesn't want to be involved. So therefore they put it there
The broker doesn't want to get involved.
in that aspect of the monetary estimate. I've dealt with multiple EXP and they basically said that, yeah, their brokerage doesn't allow the 24,
So,
yeah.
on page, on,
Congratulations. We brought all these people.
in order to avoid what she was mentioning, where it was 6%, but somebody. Yeah. The person in that, even in that situation, at 6%, somebody lost their commission.
yeah,
So here, what is the proper thing to put?
so this is 0. So for example, the deal that I had, the listing agent did lose 100% of her commission.
Right.
100%.
And to avoid that,
You can't. You're under contract. So there's no like make sure that
Make sure when you look at it doesn't say anything here.
So-
If you have a
Broker,
broker,
yeah.
it can't be in 2 places. So
Right,
if you have a
right,
broker,
right, right.
that's good.
Yeah, no, I get that, but if we're not gonna use the broker to go for it, and we're gonna go to this, what's the best approach?
whatever it is that you're offering to pay that buyer's agent.
And you can put it right here to the or the other one.
So in the situation that I had, the one that the listing agent lost everything was they had the broker to broker compensation. They did have it. And they also had the 3% here. So there was, in reality, if the seller agreed to pay a total of 6% through the broker to broker, then an additional 3, that means now the seller is out 9%. Okay, so what happened was the listing agent calls the buyer's agent and says, this is a mistake, we're only offering 3%. He's like, well, that was the offer through the broker to broker, but I asked the seller to pay for my 3% that I'm charging the buyer, and they agreed. So I'm owed 6%. So it made it all the way up to brokers got involved, legal got involved, and sure enough, they all came back and said the buyer's agent is correct. She asked for 3%. The seller signed it, agreed, and the seller has to pay that 3%.
So I have a question, if we're not using the broker to broker, okay? Because when you list it, you are asking the seller to pay a certain commission, and on there, from my understanding, I don't do a lot of listings, but from my wording, I swear to God, not yet. From my understanding is the listing agent is also specifying how they're gonna use that commission. So if they're saying, I'm charging you 6%, and I'm just gonna keep it all to myself, right? Or I'm charging you 6%, but I'm going to use some of that
3%
to the other part, right? So if they are already agreeing to, I'm charging you 6%, but I'm gonna keep a portion and the other portion going to the buyer's agent, right? So that's one agreement. And if we put it in here, we're not asking a broker to give us that portion, we're asking the seller.
Absolutely.
Yeah.
So now so the buyer's agent's double dipping.
There are agents, not the movie. Because they know that.
No. Yeah, I think I'm not getting action across correctly. So that still puts the listing agent in trouble. That's what I'm saying. Because
It depends on what section they put it
that's what I'm saying.
on their listing agreement.
Right. But so keep in mind, they have a contract, a listing contract saying, I'm charging you 6%, and we're gonna offer the buyer's agent 3%, right?
Yes.
So that means as a buyer's agent, I should be getting the broker to broker. Because now I'm requesting that from the broker.
But
if I-
remember, as a buyer's agent, you also have the buyer sign an agreement to pay you a commission.
No, right.
So that's the commission.
Can I
Yes, yes.
What it is, so that there is no confusion.
Yeah.
5A is you're going to the seller and saying, I'm gonna charge you 6. The already gonna charge you 6,
Yeah.
and we're going to share 3.
Right.
First required.
Right.
Okay, we
Right.
use
The broker
5A, yes.
supplier.
But then there's a lot of other brokers which will lead to that direction. They're using 5B, which means, let's say Keller Williams or EXP, I'm going to charge you 3%, or let's say 4%, but you're only paying me 4%. If the buyer wants to get paid or the buyer's agent wants to get paid, they have to go to 12B and request.
That's what I'm saying.
Yes. So now there's a different situation that she's trying to cover. Okay, so we're not doing 5B. Okay, that's, let's say KW and EXP, they're only worried about themselves. If the agent doesn't request it, it's not going to get paid under 12B. But under 5A, we have a lot of agents in this office that don't charge 3%. We have folks that charge up to 5% plus the $500 fee. So what happens is if the other broker, let's say it's JB Goodwin, JB Goodwin says, okay, we're going to pay you, we're doing broker to broker compensation. So on your form, you should receive it, okay? We're going to share, because when we sit down with the seller, 6%, we're going to share 3. So send me the broker to broker, I'm going to share 3. And if you're somebody from this office that charges 5 plus the $500, that's where that goes in, is that they went ahead and got the compensation that was going to be shared plus the additional amount, which in this case is 3%.
Right, and I agree with that. But earlier somebody asked, so where do we put like our? So you shouldn't get both, obviously, unless you are trying to cover the difference your buyer's proposal, right? But if there is a broker to broker, we should never be requesting, and we are getting the broker to pay all of her fees. There's no difference to the buyer. Then we should not be putting anything in this contract.
Well, what it is that if you're doing 5A, when you're taking on the business and the listing agent, when you're doing 5A, and you're going to share that compensation, or you're going to entice the other agent from this office or intermediary, right? You will be required to use the broker compensation because you told the seller, I'm gonna charge you 6 and I'm gonna share the other 3. Okay,
Correct.
so the broker compensation agreement is required. But if the other agent charges more compensation than you're offering, you can't put it under paragraph 10 because that doesn't obligate the seller. Okay, it has to be under 12B.
Right.
Okay, so PRG's offering 3, I charge 5.5. I'm gonna put that under 12B because 12B obligates the seller contractually to pay additional compensation.
Mhm.
Okay.
And that's exactly my point, that it's additional compensation to what the listing agreement states. So that's why I was saying, when the broker has agreed to pay the compensation, share the compensation, we should not be putting anything in there unless we're trying to get the seller to pay the difference.
The
Right.
additional compensation based on the fact that when the buyer's agent, remember that the language of the contract states that prior to this offer, there are other agreements that have already been in place. They're already in place via a listing agreement and via a buyer's rep agreement. So if the buyer is going, if the buyer's agent is going to charge 5.5% or 56, they're going to try to collect 3 if 3 is being offered from the seller, and then put 3 in this case.
So that's where you use both.
Yes.
So you as a listing agent, that's what you gotta make sure. See, you as a listing agent, you're not gonna put 3. It's the buyer's agent that's gonna put
Right.
the 3. And if you accept the 3 here and the broker to broker, the seller is obligated both sides.
Right. Right. No, and I agree that, but earlier I heard, maybe I heard you wrong, but when somebody asked, so if the broker has agreed to pay your compensation and they are fulfilling 100% of what the buyer has agreed to pay us, what should we use? Should we use the broker to broker or should we do this? And you said you can do either or, but not both. But I'm saying if we have a broker to broker, it should not go in here. If the
But
broker
it's
to
that's
broker already
exactly right. That's what I'm trying to make you be aware is to not accept
yes.
that. Like if you're right, if you're using a broker to broker, you're not, you have to pay attention to paragraph 12B. Because if you accept the contract, your seller accepts the contract that has an additional 2%. They're obligated to pay them what they agreed on the broker to broker, but they just got obligated again to pay an additional too. And that's what's happening over and over with contracts.
You don't have to accept that.
It's what your buyer's agent is
Prior
presenting.
to execution. That's the reason you guys have to step it up
Right.
and read your listing agreement. Paragraph, right, covers the compensation of the listing agreement. Read that a million times if you can. Okay, and then on the contract, the purchase contract, you have to be familiar with paragraph 2. Okay, because if you did the listing for 6%, you're saying, Mr. Seller, you're going to pay me, you're paying PRG Broker, and we're going to share it with everybody. Okay, and then if you don't know what you're doing, and then further commit the seller's going to be upset.
Right. Yes. Right.
Okay, so they're going to expect for you to reduce your commission as the listing agent because you protect the risk.
What's happening is listing agents are having to cut their commissions to compensate the areas that they're not tracking in paragraph 12. So even if, let's say, you took a listing and the agreement was 5% and you're going to keep 3 and share 2, or maybe half and half, 2.5, 2.5, it has happened. They accept, the buyer's agent accepts the 2.5 from the broker to broker, but then they put 0.50 on paragraph 12A from the seller. The end of the day, they still got the 3%.
Right.
They just got it in different ways.
And if you don't want it, you just
And if
back
that's
and say,
not what the free,
You just
you
go
gotta
back.
make sure you don't accept that on the future. So you have to pay attention to that. Where a lot of listing agents, they see the broker form come in and they don't pay attention to 12B anymore because they think that they got it all squared away with. So one of my scenarios is that, like, they ask for 3%, the plus an additional 3%, and the listing agent was, no, it's not the 3%. They're paying it from their buyers is paying that. it's a buyer fee. And we're like, wait, it's on a contract that the seller agreed to pick up that fee. No. If you read it. It says it's a buyer expense. So I had to be like, listen, it says on here that seller shall pay the following at seller's expenses that the buyer has agreed to pay, but the seller's picking up those fees that buyer has agreed to pay. It's a seller expense.
So let me ask, I've never had that situation, but what if a buyer is paying you? Where would you put that on?
What it is that the buyer's agreement is written in the language that thank you for walking into an open house and, right? And here's the one page or here's the long form, right? The first bucket it comes from is the one that signs the agreement is the buyer. Hey, you're going to pay me for me to show it out.
We're gonna put that on the
full services. So yes, so you're with the DRA, you're committing the buyer to pay you first. But the way that you're bringing down the stress level is, don't worry about it, just sign it, because this agreement allows me to go work for your family. So let's get in a car or we'll meet you at the next property. Don't worry about it. I'm a master negotiator and I'm going to get it from the bills from the same, right? Okay, that's the typical scenario. But no doubt about it, you just committed the buyer to sign something that commits them to pay the 3%. And what you're telling them is when you're going to negotiate that contract, is that, hey, remember that you signed that agreement in the front that, well, okay, well, I'm going to get it. The broker's offering me 3 because the broker said, I'm going to market it and I'm going to do whatever I need to, and I'm going to attract a buyer's agent to bring the honey from my client. The listing agent negotiate the entire commission, the 6% for their brokerage, but then offer to share half of it. They're securing half of it through the brokerage. But the other difference of 12B, you're committing the seller for additional compensation.
Exactly. Yeah, no, I get that part, but I'm saying I've never had to because luckily I've been paid through the seller's end. But let's just say that I have a difficult buyer and it's taking me heaven and hell to finally find them a home, and that home is only going to pay 2%. We negotiate because of closing costs and the price of the home, and now they only want to pay 2% or 2.5%. How and what document would I use for my buyer to pay me that 5% or 1%? Where would I put
At the beginning, the question is at the beginning, did they sign anything?
Yes, they signed the 3%.
What's the amount?
The 3%.
Okay, so you collected 2.5 from.
Yeah, so I'm writing out the contract now, and it says 2%.
So the buyer signed a commitment to pay you 3%. Now you negotiated 2.5 from the other broker because the broker's paying you, not the seller. Okay, the other half a point needs to be collected under 12B because then you're further commit. The broker only collected, let's say, 5%.
So then this doesn't come from the buyer.
Well, technically,
That comes from the seller.
well, you can't charge guys if you don't have any buyers.
No, I
Agreement. Who commits first and foremost is the buyer. And then you negotiate with the brokerage, the broker, directly with the seller. In this case, it's 2.5 from the broker. That's what the law control is directly through the seller. Right?
Right.
You see what I've seen? What I've seen when the buyer is going to pay that additional, I get an email from the buyer's agent telling me my buyer agreed to pay me the additional 0.5%, put it on the CD, and then they send me the buyer's rep agreement.
Okay, so the buyer's rep is this like.
So the buyer's rep agreement that's paying enough for us to collect the commission from the buyer.
Okay, I guess that's what I was asking. I mean, I've never had to.
Conversation up front. I mean, my opinion is good to have the conversation up front when you're doing buyer's rep agreement. That way they know, and if they're not planning on
Compensating,
anything, if they don't want to, that's their prerogative. And then you will just ask the listing agents, wherever you're showing, what's the compensation. If it's not, then you tell your buyer, hey, this seller is only willing to pay this much, Are you willing to? Yeah, and it's their prerogative, and then you just know. Okay, well, if they're not going to,
but you're not, you don't even need to ask.
they're not going to want to see the house.
Kathleen, you don't even need to ask. If you meet them the first time and they're going to pay you 5%, you can charge up to 5% because maybe in your mind you knew that you were going to take them to a new one building, right? Or 8%.
Oh, well, then it's up to 8%. So
Right now,
So what it is that the language is up to. Let's say in this case you put 5. and you collected 2.5 from the buyers, from the listing agent is one thing, then you collected the difference up to, you can collect an additional buyers. In this case, you only want to have one.
Yeah, exactly.
You don't need any other authorization besides the fact that you got a DRA signed at 5%. That everything's on collect.
Yeah.
Yes, so this has no doubt about it. They're agreements. They're your employment contracts. The listing agreement is the listing agent's employment contract to market that property and all the responsibilities that right. Same thing with the buyer's agreement. It's a client agreement. I'm going to take you on as a client, but you're going to pay me. But in the end, I don't know if I'm going to show you 3 houses or 50 of them, right? So at that moment, you're making a business decision. Okay, well, the other brokers only offer 2.5. I'm used to get 3. I have a BRA that says 5% because I thought I was going to be selling to your order. You have every right because that is predated prior to the execution date of your contract. You can technically charge up to that amount plus whatever the broker, whatever the listing broker is offering. Okay. One quick scenario, guys. I ended the year this year on a call with a broker that manages over 200 agents. Their agent, it was our listing. The buyer's agent was told that we don't do 12B. Okay, she was in compliance. We do 5A, so therefore I need you to send me a broker. I don't know if it was the transaction coordinator's fault or her fault. I don't know, but the day of closing, there was no broker to broker on file. Okay. And the broker told me, well, the intent was there and it's on page 10. And it was, no, can I read it to you? You're wrong. It's for informational purposes. They really need to remove that paragraph from page 10 because it doesn't obligate the seller contractually. If you take it to
There's no
court,
signatures on that page.
it does not obligate the seller, but 12B does. And that's the reason that case went all the way to, underwriting and attorneys and such. So in this case, what ended up happening is that the buyer's agent did not get paid. Now our agent couldn't keep the compensation because there was another agent. Because there's only 2 times that you can keep the entire compensation is when it is intermediary or it's an unrepresented buyer. So the seller received a credit of $9,000 or that 30%, rather than it be shared with the other agent because they didn't submit a broker to broker. Don't let that happen to you. Okay? You can't be calling me after you're in execution. Get me out of this one. I'm like, we offer classes on Friday. I have jumped on calls with a lot of you guys to try to avoid you not forfeiting your compensation. So once again, that
Not only
agent,
forfeiting as buyer's agent, but not losing it as the listing agent when they accept an offer with paragraph 12A or 12B filled out.
yes, because if you accept 12B and you only collected 6, and the other agent wants to pay 6%, the probability that you're going to have to forfeit your commission is very high because you can't commit the seller to pay 9% and say, oh, I messed up. You agree to pay us 6, we're going to show 3, but then I didn't trust the fact that you should never return to 9%. That's 9%. You have a $1 million cents rate, $18,000, right? So proceed with caution.
Yes.
What I would
So that's
recommend.
what happened with my 2 scenarios. One of them, the listing agent ended up forfeiting close 3%, and all the money went to the buyer's agent. The second one, they offered 2% on the broker to broker. The buyer's agent put the additional 1% on 12B, and they didn't listing agent didn't catch it. So then when I prepared the CD and I sent it to everyone for approval, the listing agent kicks it back and says the buyer's agent commission is only 2%. So I directed her back to the contract. Like, per the contract, they're getting 2% plus this, like the 1%. No, that's not correct. That's the buyer's paying that commission. I'm like, so I had to again and ended up getting the additional 1% from the city. But if you think about it, 1% of your sales price can be a lot.
Yes.
Now, one more thing, guys. And I told the broker, because he thought that we could just solve it amongst ourselves, like good old boys. Well, what got us in trouble to begin with was that is because the reason that this lawsuit won was because the seller in their mind was thinking, okay, well, why am I paying the person when I'm my agent? Okay, well, it's to bring a qualified buyer, of course, and you want to compensate them, but it doesn't matter. They never understood that if you represent me as the listing agent, why do I have to pay another agent that's not in your company? Right? So imagine having conversations, right? About, okay, fine, let me go back to the seller and get you that extra 1% because I missed it. Blah, 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 blah. At that moment, you didn't uphold fiduciary duties, but you just got in your car going 100 miles per hour without your seatbelt. Because that could lead to a potential risk. Because you failed the seller. No doubt about it. You are in complete violation of fiduciary duties, right?
And your credibility in general.
Well, yes, but the main thing is contraction. Contraction. So, and then the right thing to do in that case is go, okay, I'm not going to get it from the seller. Do the right thing, forfeit the commission or reduce your commission so that you don't have to involve the seller. Because if the seller is impacted, trust me, and they talk to the wrong person, what do you mean you pay an extra one? You sign paperwork, and that's going to end up in a lawsuit, right?
Sounds like an NR lawsuit.
Well, yes, it's a long time about it. These lawsuits aren't going away. On the contrary, I think that it's only the beginning, okay? Because everybody is suing out. Okay. Well, the worst part of it is this, and that's one experience, and you can't buy it with you, right?
Yeah.
The escrow officer, because she didn't know on a different type of company, made it worse and threw gasoline on the fire because she called the listing agent. The listing agent took her the business. And then she was, why aren't you paying the other agent? Because the seller wouldn't see the documents. They said, no, my agent told me that because she didn't turn in the broker to broker, it is to assume that the buyer was going to pay their agent. So the compensation, because she wasn't doing both sides, she wasn't doing intermediary, and it wasn't an unrepresented buyer, we had to give her credit for the $9,000, right? So then her net was $9,000 more, right? Because the other agent didn't turn in the broker to broker. So at closing, she was tight, and it turned into this big debacle on 12/31. Okay, so what ends up happening is that the seller knew. The seller knew she wouldn't sign. And then imagine having to double back. I know you're going to pay and blah, 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 and you messed up and I didn't catch it. Blah, 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 right? Having those discussions. Huh? So when I was talking to the title company, they didn't understand it. I had to explain it to her. So why would you want to get involved? This is the compensation. I mean, that's like, no, you don't want to get involved. It has to be discussed amongst the group.
Yep. One last question, so we can, I know, move forward because it's a touchy subject. Of course, it's our income, right? But are we authorized to, like, for example, if I do sign a contract, but my client says, yes, I'll pay you 6%, but because you're doing X, Y, and Z, I only want to pay you, 4%. You can only give them 2%. Right?
What it is that when you take on the listing agreement and they agree to pay,
it always has to be even.
It
always has to be even, so that 6% needs to go 3 to 3.
Remember that on a trade transaction, which that includes FHA, VA, USDA, and conventional, 8 paper caliber loans. HUD allows up to only 8%. Okay.
So my question is, can I share my listing agreement with the buyer's agent if they feel that, oh no, are you sure? I'm just saying this because this has come up.
You can have to, but if you want to keep the word and whatever you can.
Okay. I'm just bringing this up because it came out on Shift not too long ago. One agent was asking the other or the
honest agent, and you're keeping 3 and sharing the 3, and that's it. But if you tell the other agent, hey, we're only paying 2 because I took on the listing for 4, table, you're getting more compensation, and we were involved in that. The crazy listing agent at a different company even sent a text. Oh no, we're only paying you this because I only collected this, and at the table, the CD said something else. So we sent over the text saying, maybe this is going to end up like a complaint.
Because
because
you have this on there and I was like,
yeah, you're being dishonest and negotiations and everything. So she did the right thing and paid our agent because she knew where it was headed.
Question, regarding your initial point regarding that last question, isn't it our discretion to utilize or to share to whatever degree that or that 6%?
What it is that when you two take, you need to read your listing agreement with
Right.
this.
Right.
When if you take on the listing
Right.
for 6,
Right.
you can just put 2 if you
Right,
want.
right.
Okay, what you cannot do is change it and say, okay, well, I'm gonna pay you 1
We're
because
changing language.
we change it later, not doing contrary
oh,
execution
Yeah.
because
Right,
then you
right.
disclose compensation to the other agent.
Right.
You can't,
Right.
you can't take on a listing on January 1st, sharing 6% for free,
Uh-huh.
and then change it to something else to the seller's detriment or deviating from the listing agreement for your.
But when you're setting up the agreement, you have the discretion to say 6 and.
Well, I'm gonna charge you 4, now I'm only gonna pay out 2.
Right, right.
Okay, and at that moment, it's a problem because you probably won't get showings.
Right,
Yeah.
right.
Yeah.
Okay, do the right thing. If you're gonna take
Right.
it, you charge 2%, but still pay for it.
That's right.
That's the right way to do it.
Right.
Okay, because it's a lot of work to be out in 100-degree weather, you know, doing something else, and not getting paid full compensation. Do the right thing. Okay.
But there's not a required incentive to be here to get the. You
Yeah,
have
so you
some.
get back to 8%, guys, and never this. There is no limit. There's no limit. Only the only time that there are restrictions is FHA, USDA pension rules. Those are trade government loans. Okay, or government backed loans. Everything else, I have seen up to 15 and 20% commission on approved land or commercial land. Okay, it's crazy, right? Great.
The 25% I've had for unapproved
All.
vacant lot, right?
It's even fellowship, don't do that, because then, if they talk to the wrong people, and then they feel that, you know, at a party, on the barbecue, why do you need to church together? All of a sudden, they wasn't sitting and one considering, and especially when it's other than because something so long, trouble that is that.
yeah.
Yes.
They'll take advantage.
All right, so I love this. See how this was like, this is what I wanted y'all to.
Got one thing.
Exactly. Awesome. Okay, let's put everyone understood 12B, right? At
What is
least,
12 about again?
at least enough to like know that's something important.
Yes.
All right, let's move on to the next.
The question on C. So then, because you have B and then you have C. So explain C.
See, that's closing cost. Closing cost.
Okay, that's separate.
That's
from your B.
separate. That's separate. That's what the seller
Oh,
is
yeah.
paying towards buyer's closing cost.
That's one that was always there before, but.
I did have an agent though that put 3% there and thinking that they were asking 3% buyer's closing cost. I mean, the seller paid 3% towards the buyer's closing cost of the sales price.
Yeah.
So that's not what that means. Two totally separate lines. All right, let's go over. We're almost done. Paragraph 20. This is a really important one. No one pays attention to paragraph 20. Good for you.
It used to be a spot, right?
It's paragraph 20.
I know, but it used to have a
Yeah.
place to check it.
Oh, like to see an addendum for it?
The
No,
owner
the
is
person
on the list.
Yeah.
The check mark on the list.
I think that's on
Yeah,
your
definitely.
listing. That's on the
list.
Yeah. That's on your agreement. Okay, number 20, which is foreign, if you are dealing with a foreign person. A foreign person is someone who is not even because it could be a resident alien, it just does not have a social security number to report the sale to the IRS. Okay, so if you have a listing and you have a seller, this is why this is a FIRPTA law. It's called FIRPTA law, and this is what happened. FIRPTA, FIRPTA. So back before 2017, US is an open market, right? Anyone could buy a piece of land here, right? Anyone, any country, US is open. So, but if I'm gonna use Mexico because that's where we're from, right? But I can't go to Mexico and go buy their land. I can't. They have a closed land, right? Now, what's happening, a lot of foreign nationals coming into the United States, buying properties. Stone Oak is full of foreign nationals, and they buy the properties, they rent them, they sell them, and before 2017, if they didn't have a social or a tax ID number, we were just required to put 00000000000 as their social security number, and we don't report that system.
And so it's county and it's okay.
So then IRS comes down and says, wait a minute, you have all these foreign investors from other countries coming and buying property in the United States, collecting rents, selling these properties, making a lot of money off these properties, and they're not paying a dime to the IRS. Where you have your U.S. citizens that sell a property and you get hit with 10-15% capital gains taxes, depending on your tax bracket, and how is this fair, right? So then they came up with the FERPA law, which is that right there, paragraph 20. So now the FERPA law after February of 2017, it says that any foreign national that doesn't have a social security number or a tax ID number to report the sale to the IRS, now we have to collect 10-15%, depending on the category of or the sales price. We have to collect the money from the top, not the net. So it's 15% of your sales price, which is a lot of money. Okay. Then after we collect the money, our responsibility as a title company is to collect the money from the seller. But then, if you read that paragraph, it's the buyer's responsibility to turn that money into the IRS along with the 8288 and 8288A. Let's read it.
Now you think they're doing it? No.
But they're doing it.
They are?
They absolutely are doing it. Okay, so let's read it. If a seller is a foreign person, or if the seller fails to deliver an affidavit or certificate of non-foreign status to the buyer, that the seller is not a foreign person, then buyer shall withhold from the sales proceeds an amount sufficient to comply with applicable tax law and deliver the same to the IRS together with the appropriate tax forms, which is an 8288, 8288A. So those are the two forms that we print out for the buyers. The buyers is responsible for filling them out, collecting the money that we're going to cut a check payable to the U.S. Treasury, and we hand the 15% check to the buyer. We hand the forms and say, fill it out, mail it in. Now, do a lot of people do it? Some do, some don't. You know why they do? Because now the buyer took on that responsibility of the capital gains business.
And the forms have all the seller information.
It has the buyer and the buyer's information. So the buyers have to send them in. Otherwise, the buyer just took on that 15% liability of tax. And it's not like the check is payable to them that they can keep it. The check is payable to the IRS.
Well, does it say the buyer has to collect or they just have to do one of them?
We have to collect, so we collect with the buyer's supposed to collect and submit with the taxes. So this is anyone that you are dealing with no social security or tax ID.
Or the buyer is liable then to the IRS.
The buyer is liable to the
The buyer.
I mean, that was more about the process, the practical mechanics of it. The buyer has to collect it.
The buyer has to collect it, but we give it to them, like we collect for the.
You collect for
We
them.
get it from expense. We give the buyer a check at closing.
I know.
With the
And then
forms,
what they do-
we even print forms for them. They have to do it because otherwise they are liable. Now, are there loopholes? Of course, we have to find the loopholes, right? Always. Now, there are some forms that can be signed by the buyer. So listing agents, if you have a foreign national someone who doesn't have, we don't care about their immigration status. If we're talking about the IRS, are we able to report this sale with a tax ID number or a social security number? Okay. So, if you know your seller does not have a social security number, you cannot sell to anyone that is not going to occupy this home as their primary residence. Because the loophole is an affidavit that the buyer signs at closing saying, I am 18 years old and over. I intend to occupy this home as my primary residence for the next 6 months. It was homestead to the seller. It will be homestead to me. Don't collect the penalty. If you get a buyer who's willing to sign that form, the seller walks away free.
What if it's a piece of land?
You're done. If piece of land, automatically
Government.
purchased. Automatically purchased.
And if the seller was not a homestead property,
Automatically purchased.
so it's only homestead to homestead.
Absolutely. Now, remember, in the state of Texas, even if you own one property in the state of Texas and you don't live here, it still could be considered your homestead. Because Texas is a homestead state. So I have a lot of foreign nationals because of my Eessential. I deal with a lot of foreign nationals and they own properties here. And as long as they have it as homestead and they don't have another one, it's still homestead as far as I'm concerned. See what I'm saying? But if they have multiple properties, they're investors with a lot of properties, well then we can't. Exactly. Or if they have vacant land, if they have apartment complexes that are not primary residents, then how can you get away? We can't hide that from the IRS. So when you're dealing with vacant land, that's one. What a lot of people do, transfer properties over to an LLC, have a tax ID number. However, if it's still capital gains taxes, you still have to but as an individual, I'd rather pay and try to write off some things than to collect from the top. I could at least figure out how to, pay less taxes to the IRS versus for someone to collect 15% off of my sales price.
You know why they're putting the responsibility on the buyer?
I don't know why they did that, but Trek did that. That Trek put the responsibility on the buyer. And as of right now, I have closed many FERPA deals, and many of them, the buyer is willing to sign the affidavit. As of right now, I've only had the one person out there.
I think my idea would be if the seller's foreign, they don't live here, right? They're not gonna pay taxes. You gotta make somebody pay, like the government wants that money. So if the buyer's gonna buy it, then that's the asset that they have. And I'm just thinking maybe that's the reason why, because they want to ensure they get paid. Because if someone sells it and they're out of town, they go back to Mexico and never come back, the government's never gonna get that money. So they have to keep
That's
somebody else
exactly what
liable
was
for that.
happening. That was
Yeah.
exactly what was happening.
I guess the question is more like, I get what you're saying,
Yeah.
but why they put it on the buyer instead of maybe making
The title company.
the title company?
I think it should have been a title company.
Yeah.
I really think that's something, since we have all the information, we have everything, it should have been on the title company,
Yeah.
but the title companies prohibited from touching it. But you do provide that to the buyer, and it's their responsibility to do this. And I even sit next to them. Yeah. How do you?
Well, they're again.
I can fill up the form, but I can tell you.
It's free as the buyer's agent to find out if we're dealing with a transaction.
Yeah, ask the
Yeah.
listing agent.
The listing agent is supposed to disclose it
Yeah.
from the beginning.
Yeah.
Now, has there been lawsuits over it? Absolutely. Absolutely. We've had a lawsuit over it, and the buyer sued. This is crazy what happened. So this lawsuit happened back in 2021 when the interest rates were at somewhere even 1.99 and 2% for them. We get a $400,000 contract, right? And everything is going well. We're under COVID, but we're still, that's why we're probably the most, And we're now back at the office. It's the end of 2020, and we were presented with this contract, right? No one ever disclosed to anyone that the seller was a foreign national. They didn't live here or anything. Until we started processing the file, we asked the seller for their payoff information. We asked them for their social security number. I don't have anything. I don't have. What do you mean? Like, you were your social? Well, no, I'm not even out in the United States. Okay, so now we have a photo proof, right? So we started. Not That's okay. So we then call the buyer's agent. We have a problem, and the seller's like, no, you're not taking 20 or 15% from the sales price. It's not gonna happen. I would have to bring money to the table. I'm not doing it. Cancel the contract. Cancel the contract. Well, the buyer loves this property. Their parents live next door. They've already paid for inspections. They've already paid for principal. They're pretty they're to invest it, right? So then the seller says, "Oh, I got a heart attack due to COVID. So everybody leave me alone because I need to recover from." Signs an amendment. The listing agent has an amendment signed to extend the contract. So the seller's recovering from a COVID-related heart attack or whatever he got, and months go by. That property that was worth 400,000, now we have a bidding war a few months later in 2021, when now everything skyrocketed. The properties are now, you have to offer $50,000, $60,000 more than what the sales price is. And now the market is completely different, right? So the buyer's patiently waiting. The listing agent convinced the buyer and the seller to allow them to sign a rental lease and just move in until he recovers or whatever. So now they're in the property. Okay? So months go by. We finally get a hold of the seller again. The seller's like, I'm not signing. Forget this. Cancel the contract. I'm done. Blah, blah, blah. Well, now the property that was worth $400,000 is no longer worth $400,000. Now it has an appraisal of a lot higher. So now we have a lawsuit. So now the buyer sues the seller and the broker and subpoenas our buyer. So we have to submit the file to the attorneys, and the buyer wins the property in courts. Wow. And the seller lost it. And the listing agent no longer practices because they lost their license over this, and the broker took a huge hit over this
When
transaction.
you say they lost it, they have to sell the property and take that 15%.
So they didn't show up to any of the hearings,
Right.
and the judge awarded the entire property to the buyer.
Without the buyer having to pay anything.
Wow.
Wow.
Really?
You think that
They don't pay
like
mortgage. They pay
it'd
the
have to be a
mortgage.
default and still make the transaction go through the versus just give it to them.
So the buyer ended up paying the mortgage off through the court, and the buyer won the mortgage. So the buyer still have to pay the 15%. No, the seller's done. Like the
seller walked away with zero. So the buyer just bought it for what was owed.
Which, yeah. Yep. And the listing agent lost their license, and the broker.
Why did the listing agent lose his license?
Because the listing agent never disclosed to anyone, and apparently there was emails or tech conversations that the listing agent knew that he was a foreign national.
Where did you disclose that?
Apparently it's on the listing.
Yeah. Right.
It's on the listing agreement.
Yes.
And then you have to put it on the agent note from MLS.
And from there back, he knew and did not communicate that to you.
I'm gonna go over the very last one just because I always go over time. I'm so sorry. But we're gonna go over one last thing, one last scenario when it comes to which is paragraph 8, the addendums, okay, marks. This scenario was 2 years ago. I had a property, 100 acres that was under contract, and seller agreed to sell it with the mineral rights. Buyer paid a lot of money for the 100 acres and the mineral rights, and there was supposed to be an addendum for the mineral rights to convey, and the buyer's agent forgot to submit the addendum where the buyer was asking for the mineral rights.
If I know it later.
So it's without the mineral
It
rights.
flows without mineral rights. 100 acres without mineral rights. In this, the buyer's agent almost had a stroke over this. He was freaking out because the whole reason of the 100 acre was they wanted the mineral rights. And luckily, this seller was an older gentleman, very, very honest. And when we approached him and said, sir, apparently you're supposed to convey the mineral rights on the deed, there's supposed to be certain language on the deed. And that wasn't done.
It was checked off here.
It did not get checked off, and we didn't have the mineral rights addendum. He had it, but he didn't provide it, and we closed and funded without it. So then we showed him the addendum, and he agreed to sign a correction deed, and he conveyed the property again with the mineral rights, and it got fixed, but he didn't do that.
That was the honorable thing to do, and he did it. That's old school.
Because he was like, oh, that's right. Yep. So remember to always attach your addendums to the contract, okay? Did y'all learn anything? That is it. The HOA addendum, that's a whole nother thing, but I think that's a whole nother.
We're gonna do that next month.
Okay.
Yeah. Melanie sold these there. All right.
All right, well, if you guys need anything, have any questions, if you want to have one-on-ones, you want to lunch, you want to know more of things that we offer at what we cover tonight, just reach out to Brittany or reach out to me. I will be more than happy to have more trainings for you. Yes.
Let's show a picture over there of everybody.
Yeah.
Next time you leave, we offer you.
I loved all your stories and
I
if you guys want, I do teach another class that's on commitments and scenarios on your commitments. What you'll get on title with your sis, with dead people and well that's
Hey, y'all, like one more thing, you can bring food, it's 2 hours of per time, but we're getting to the board, it's never have to change your own business.
Thank you very much. Thank you. Yeah.
I need to.
Pictures first?
Yeah, let's go to the 6 first.